Counsel, may it please the court. My name is Mike Norris, and I'm the attorney for the plaintiffs in this matter, Rhonda Banwart and her children. The issue before the court today is whether or not post-event evidence of intoxication can serve as the basis for an inference that a bar knew or should have known that a patron was intoxicated at the time of service, or at the very least, knew or should have known that the patron would become intoxicated at the time of service. This court has actually ruled on this issue previously in Smith versus Shagnasty. The court in that decision held that the conduct of the patron subsequent to the service of the alcohol that the patron was consuming was in fact appropriate to serve as a basis for an inference that that patron was intoxicated.
As I read, Mr. Norris, as I read Shagnasty's, I think Justice Streit's opinion says that it was really the confluence of two things. One, that the assailant was visibly intoxicating and holding a beer that clearly one can infer had just been served. And second, that the bar kind of protected the assailant after promising the victim that they would hold her. The bar let her go, and and Justice Streit said the confluence of those two facts allows for an inference. Here, all you have is, sometime very shortly after the person leaves the bar, but a long time after she claims she had been last served, there's a 0.14 blood alcohol level, but you have no toxicologist, you have no statements or evidence from any of the servers, any of the people that were with her, and the driver says, I was only served 3 beers and the last one was an hour before, right? Isn't that the full sum total of the evidence?
No, it's not the full sum of the evidence. Certainly there's substantial evidence beyond that we gather from Officer Graham's testimony. But I would point out, with respect to the decision in Shagnasty.
Right, fair point.
Yeah, and I'll get to that evidence here in just a second. But with respect to the issue with Shagnasty, it's true that there were two pieces of evidence that the court primarily focused on in their decision. One, the conduct of the patron after they'd been served their last beer, and that was they were loud, obnoxious, unruly. And number two, that the bar, at least there was the argument that the bar had protected the patron by letting them leave before anybody was able to determine whether or not that patron was actually intoxicated. In this case, I'd argue that the evidence is actually better, because in this case, we were able to determine whether or not the patron was intoxicated at the time they left the bar. And we know from the evidence, and I'm going to discuss here in a second, that the patron was not only intoxicated, she was significantly intoxicated. She had a blood alcohol level of 0.143, nearly 2 times the legal limit, only minutes after she left this bar. The facts in this case are such that the driver, or the patron, her name was Michelle Campbell, she'd been at this bar from approximately 4:30 in the evening until approximately 9 p.m. At night. She had arrived at the bar immediately after work and was with coworkers. And the evidence, I think, is undisputed that all the alcohol she consumed on the evening in question was done so at the defendant's bar, okay? She left the bar at approximately 9 o'clock, gets in her car to go home. A mile from the bar, only a few minutes after she leaves the bar, she strikes the rear of my client's vehicle while it's stopped at a stoplight. Officer Graham, a West Des Moines police officer, arrives at the scene almost immediately, and upon talking to Miss Campbell, he instantly, or at least as soon as he talks to her, he observes several signs of intoxication. She has bloodshot, watery eyes. She has slurred speech. She appears to be visibly emotional. He asked her to provide her driver's license, her registration, her proof of insurance, and she was unable to do that. She was confused. The inference comes from, if we logically ask ourselves, if this was her condition only a few minutes after she left the bar, is there a reasonable inference that if we were in the bar at 8:59 just before she leaves, wouldn't we observe the same conduct? Wouldn't there be an inference that her conduct would be exactly the same as it was when Officer Graham observed her? And I think it's important to keep in mind that when Officer Graham first meets Miss Campbell, when this accident occurs, he has no idea that she's been at a bar drinking. He makes these observations, the observations of her significantly intoxicated or impaired state. He makes those observations without any previous knowledge that she had been consuming alcohol or had even been in a bar.
Using these facts, couldn't a jury or a finder of fact find that she might have had more than 3 drinks?
Certainly.
She might have drinking a little after 7:30? Because if she drank at 7:30 and her blood alcohol at 9:52 was 143, on 3 beers, your alcohol level has to be going down.
I couldn't agree more. I couldn't agree more. And here's what I would say about the evidence of the 3 beers. First of all, that evidence comes solely from the testimony of Miss Campbell, who first gave that statement when she was being investigated by Officer Graham for an OWI. She said she had 3 beers. One time I asked an officer, how many beers does it take to get intoxicated? And he told me 2. And I said, what do you base that on? He said, every time I've arrested somebody for OWI, they told me they had 2 beers. I said, okay, well, this person had 3 beers, they said. Now, the second time we hear that from her.
I would say there's probably, if you took a survey of this courtroom, there's probably most people would agree that she had more than 3 beers and that maybe the last beer. But what do you do with the gap in the evidence? Isn't that your obligation? You didn't present a toxicologist. You didn't, or a statement, an affidavit from a toxicologist. You didn't present evidence that of someone else. Well, actually, there were about 5 rounds served, and the last round was served at this time. And it's possible, even if she had more than 3 beers, it's possible she drank her beers that were from a pitcher or beers that were served to colleagues or something else. And we just don't know, right?
Sure. Let me finish my thought on the issue with the 3 beers. And I think you basically alluded to that. The finder of fact can either accept that or reject it. And I suspect strongly that when this case goes to trial, the finder of fact, the jury is going to reject her testimony that she had only 3 beers. Now, with respect to your question, Judge Mansfield, I would say it really doesn't matter. And the reason it doesn't matter is because we know beyond a reasonable doubt, because she was convicted in a criminal court, she pled guilty. We know that she was intoxicated when she left the defendant's bar. The alcohol she consumed in the course of becoming intoxicated occurred at the defendant's bar. And the inference that we can draw from that, along with all the testimony that we have from Officer Graham, is that when she was at that bar, while she was consuming alcohol served by that bar, she became intoxicated. There's no dispute about that. And so from that, and from the evidence that we have from Officer Graham, I would submit to this court that we would all be able to conclude and draw a reasonable inference that we would have observed the same signs and symptoms of impairment and intoxication had we seen her before she left the bar. That's the evidence that's what the inference is.
But that's not the test, whether she left the bar. They have to have the same signs and symptoms when she was served that last drink.
When she was served that last drink.
Not when she left the bar.
That is correct. And here's what I would say with respect to that. And I would point to Shagnassi, but I would point more so to the case that this court relied on when ruling on Shagnassi, and that was actually a case out of Indiana. It was the Ward case, and here's what the Ward case said about that. When viewed in a light most favorable to the non-moving party, the fact that a bar served even 1 beer to a person who shortly thereafter was in a state of serious intoxication gives rise to a question of fact whether the intoxicated person was visibly intoxicated at the time of service. What I glean from that, Your Honors, is that when you have somebody who leaves a bar and they're in a significantly intoxicated state, as Ms. Campbell was, an inference exists that bar served her not only to the point that she was intoxicated, but that they knew or should have known that while they were serving the alcohol, she would become intoxicated. And that's all the legislature requires us to prove. We only have to prove that they knew or at the very least should have known that the service of alcohol would lead to her intoxication, that she would become intoxicated. That's it.
Is it possible that when they served her, it was her last beer, and these are high alcohol craft beers, right? That she may have looked just fine, and it was that last beer that kind of put her over the limit?
Well, I think that question would be one that a fact finder would have to decide once we conclude, or once this court concludes that there was a reasonable inference for the fact finder to make that decision. And I think they would. Again, whether or not it was a high concentration beer, I think makes no difference in regards to the decision that this court will make. She was clearly intoxicated, and they were the only ones that served her alcohol. And she was clearly intoxicated immediately after leaving the bar.
Let me ask this question. Why are you equating the intoxication under the dram shop statute to the artificial level of 0.08 picked by the legislature under the OWI statute? What is such that makes those the same standard?
Well, the standards are not exactly the same, but this court has said, and they said this in Shagnasty, that the blood alcohol content of the patron is an important factor in determining whether or not they were intoxicated. Just as important are the signs and symptoms of intoxication, that Officer Graham noted in his report: the bloodshot, watery eyes, the slurred speech, the emotional state that was unusual. She was laughing, crying, her inability to follow instructions. All of those things combined with this high blood alcohol level that we have is evidence that a reasonable fact finder can use to infer that this individual was intoxicated when she was at the defendant's bar. I would also argue that the high blood alcohol level gives a significant degree of credibility to what Officer Graham has testified to. When you have somebody with a blood alcohol level that high, and you have an officer saying, hey, as soon as I see her, even though I didn't know she was at a bar and I didn't know she was drinking, but I could see that she had bloodshot, watery eyes, and I could hear her speech was significantly slurred, and I could immediately observe that she was not able to follow my directions. And then you see, hey, she's got a blood alcohol level that's almost 2 times the legal limit to operate a car. A reasonable fact finder can infer from that she was in the same state.
What do you make of the fact that she admitted she was buzzed but not intoxicated?
Well, I think there's a commercial on TV that says buzz driving is drunk driving. I don't know that there's a legal definition for the term buzzed. I do think that is indicative of her own knowledge that she was feeling the impact or the effect of the alcohol that she had consumed while she was at the defendant's bar. And I think it's another fact that the jury can certainly take into account when inferring that this individual was intoxicated at the time she left the defendant's bar.
Are these questions we've been asking really just kind of weighing the evidence that we have, and isn't that what the jury's supposed to do?
I would agree 100%. Judge Waterman, this is a case that should not have been dismissed on summary judgment motion. This case should have went to a jury, and the jury would have been the fact finders to determine whether or not we met the burden of proof under 123.92.
If we hold that this record is insufficient to even generate a jury question, what would that do to the purposes of the dram shop law?
Well, this court has said previously that the intent of the legislature with respect to the dram shop law was to be a hand of restraint in regards to those who are permitted in this state of Iowa, to serve alcohol to patrons. And because of that, this court has said on numerous occasions that the dram shop law is construed liberally. And what it would do, I think, is have a significantly chilling effect, on dram shop cases that are brought. And that certainly is not the intent of the legislature. It's certainly not in the interest of the public to give sort of an out. And let me expand on that, because I really think what you have here, when you're talking about the evidence of someone's intoxication, the best evidence of their intoxication is going to come from somebody trained in evaluating the intoxicated state of an individual, such as an officer. If we relied on the evidence from the bar, what would a bar employee say in a scenario like this? They didn't seem drunk to me. They were sitting in the corner, they were eating their food, and they made no noise. There was no reason for me to think that they were intoxicated, even though I continually put beer in front of their face all night.
On that point, Does the record reveal, summary judgment record reveal how many different servers were serving the table at which she was sitting, or?
It does not, I don't believe it does, Your Honor. I think I think Ms. Campbell may have testified that she had the same server all night, but I don't think it was part of the record. I could be wrong about that as well. So, but I was going back to what I was saying.
You'll have an opportunity to sum up in your reply.
Thank you, Your Honor.
Mr. Zenor.
Mr. Chief Justice, may it please the court, counsel, Adam Zenor on behalf of Draft House 50, legal name of 50th Street Sports. This court, and we're asking this court to affirm the summary judgment grant of the district court. This is a case where plaintiff has simply failed her burden. We are at the district court, and all plaintiff comes to the district court with is an after-the-fact BAC, and as Justice Mansfield has pointed out, no expert. As this court's acknowledged, whether in Mr. Norris's argument or the one before, this court is guided by the language of the statute. When Mr. Norris's client...
Can I ask a question here? I mean, I think I agree with what you're saying. There's really not a lot of direct evidence. But do we give less weight to circumstantial evidence?
You don't. I agree with Justice Wiggins. There's absolutely no direct evidence in this record that would cut for plaintiff Banwart's. Different.
Well, she was served there, and she only drank there, I guess, and she felt buzzed. I guess that's the direct evidence.
I would respectfully disagree. The direct evidence on scienter and intoxication at the time of service, which is a statutorily prescribed standard, at the time of service, plaintiff would have this court drive past the statutory language that the signs of intoxication must be, quote, at the time of service. And here's why.
But you have like 5 or 6 states, and some of them have no statute, not should have known statutes, that say the fact of intoxication after you leave the restaurant or the bar raises the inference that they were served and intoxicated. I mean, how do you distinguish all those cases? And some of them were no states, not only no or should have known states.
One, this court's interpreting the language of the Iowa statute that at the time of service. 2, the only case this court has been provided by plaintiff is the Ward case from the Indiana Court of Appeals.
We can't do our own research? New York, Alaska, Pennsylvania, Washington?
You certainly may. The issue, though, Your Honor, is the summary judgment standard in Indiana is not Iowa's summary judgment standard. This court announced in 1991 in Hobby Brinken that it's incumbent upon the plaintiff, if Ms. Banwart wants to bring a tandem dram claim in addition to her tort claim, as to Ms. Campbell, she has the obligation, this court has said, the statute prescribes, and this court has said in Hobby Brinken, that it's incumbent upon her to adduce affirmative evidence. It's not the dram's obligation to prove the negative, the lack of evidence. It's her obligation to demonstrate facts, sufficient admissible facts that at the time of service she presented in this fashion.
Well, under that standard, wasn't Shagnaski decided wrongly? Because we took the inferences.
No.
We took the inferences of the holding the bottle and in the bar, and that was a real thin case. But we found there was enough to get to a jury.
You did. In this case, as the district court rightly pointed out, the Court of Appeals agreed, this case has wholly different evidence than the Smith case. The reason this court was able to extend this subsequent intoxicated condition inference in Smith was the pairing, as Justice Mansfield pointed out, was the pairing of these two, not just the subsequent intoxicated condition inference, but also paired with what this court called spoliation or the runaround that was given to Ms. Smith in that case, saying we'd hold doe, but they, of course, didn't. And, of course, we allow a fact finder to infer on scienter, you can affirm, you can deduce improper or basically it allows this court to get to knowledge with BAC alone and no expert. If this court, I wanted to address the question that was asked regarding, well, I think we can all agree among ourselves that maybe it wasn't 3 beers. Well, that's not the record.
Oh, but we don't need to accept her testimony or her statement that she drank 3 beers, like counsel suggests. People get arrested all the time. Well, how many beers do you have? 2, 3? A jury would be free to disregard that. And in fact, she had more than 3 beers. We know that shortly after she left the bar, she was intoxicated and substantially intoxicated. Don't need to have an expert to say that. And we know she was at the bar for 3-4 hours. Can't we infer that?
No.
Well,
You
why
can't
not?
infer. You can't infer because that's not the standard on summary judgment.
What is the standard on summary judgment? The standard,
Speculation and conjecture are inappropriate. You don't have that in this record. It's incumbent upon the plaintiff. It's undisputed in this record that 3 beers are served. That was undisputed. I would also point the court.
Let me interrupt you for a second, because I think it's the Washington Supreme Court where the person testified what they had to drink, and the court said, and they found, based upon the being drunk afterwards, the court said, you don't have to believe what the person said, that they only had 3 drinks. A jury doesn't have to believe that they had 3 drinks. A jury can reject that in light of the other evidence that it was 1.43, almost 2 hours after she said she had the last beer. And if the jury rejects her testimony through circumstantial evidence, can't they reject all her testimony?
The court, I would respectfully submit the court's putting the cart in front of the horse. We are at summary judgment, and it's incumbent upon the plaintiff to produce admissible evidence relative to Miss Banwart's intoxication at the time of service.
What if Miss Banwart said, I was drinking beer on the moon, and there's nothing to refute she was drinking beer on the moon? Does that mean, for summary judgment purposes, we have to believe she was drinking beer on a moon?
What this court would be presented with at summary judgment in reviewing a district court's finding is what's in the record. And if the record evidence is devoid, I agree, if we modify the court's hypo and Mr. Norris, or excuse me, the Banwarts are here with an expert to talk about what the BAC would have been, and absent, again, we're assuming this BAC after 3 beers.
You didn't answer my
not 2.
question. Do we have to take as true that she was drinking on the moon?
You'd take as true whatever the facts are in the record in light most favorable to the non-moving party.
Well, it's not only the facts, but the reasonable inferences from the facts that we must deal with here. And I guess the critical issue is, why isn't it a reasonable inference that a person who has the BAC that this driver did in temporal proximity to when she left the bar, that she also was in a condition when she was served the last drink, that the bar knew or should have known that she would be served to the point of or beyond intoxication? It's what is the permissible range of inference is the key question here. And so I'm going to give you a last chance to tell us why it's not a reasonable inference in this case that she was either intoxicated or would be if she was served that last drink.
3 reasons. 1, to allow that inference in Smith, this court needed both an after-the-fact inference together with spoliation. You don't have spoliation here, number 1. Number 2, You have affirmative facts in this record that are contrary to the facts in Smith. In Smith, there were no facts that she was, that Doe had a sit-down conversation with coworkers, that she didn't stumble, that she didn't lose her emotions. The undisputed evidence in this record is that's what occurred. We would acknowledge, to Justice Wiggins' point, if there would be an expert that would dispute that, what is undisputed evidence in the record, that this is how she presented, keep in mind whose burden that
Well,
is.
you know, I take your point on the expert testimony and the extent to which that might have been useful in this case. But isn't in the area of matters surrounding intoxication and drinking alcohol and its effects a subject that is in Iowa within the range of lay testimony and doesn't require expert testimony? Is that something we should consider in making our decision here?
I think the BAC, conflating a BAC, a hardline BAC, in 12392 with 321J is a complete error. The legislature has decided we will draw a bright line with respect to BAC under 321J and impose liability on drivers that elect to drive over that bright line BAC. The legislature, in its infinite wisdom, has not elected to do so in 12392. In fact, in 1986, the legislature abrogated strict liability. To engage in this exercise about what if, could we, what are we going to do, set aside the scientific viability of just tossing a BAC to a jury and deciding this is how this might come out without any interpretation is wrong. Moreover, I would add, and so to move down this road is to revise the statute and invite strict liability back into the analysis, which not only is not in the statute, but the legislature actually told us not to do that. And so it's a fundamental error. I also want to talk just a piece about this extrapolation, where the court has said, well, we can kind of extrapolate this, that, and the other thing. Not so. The record is that and it's in your record, I asked Officer Graham, was the AIP, or alleged intoxicated person, Miss Campbell, was she truthful and consistent in her reporting to you that she had had 3 beers? His answer, yes. The record is devoid. And appreciate within the province of this court,
Can the jury decide that fact? I mean, maybe the officer did testify to that, but whether or not she drank 3 beers, could a reasonable jury conclude, based on the fact that she was arrested a mile from the bar and had .143 and watery eyes and slurred speech and emotional highs and lows and had difficulty finding her registration, could a reasonable jury conclude that she had more than 3 beers based on that?
no. The district court said no.
Wow.
The Washington Supreme Court dismissed a AIP, the alleged intoxicated person, who said she had 3 cognacs because it was implausible with the facts. And they said a reasonable jury could reject that under a dram shop case. And we don't apply that law here?
It's not, I would caution the court not to pervert its standard on summary judgment and hearken back, overrule Hobby-Brunken of 1991 that says, if you're going to bring a dram case, together with the statutory obligation, plaintiff has the affirmative burden of adducing evidence. If there was some evidence in this record that could be presented to a jury that would refute that.
Under your theory, we could say that the .143 is not evidence, that the slurring speech is not evidence, that the watering eyes are not evidence, that the stumbling is not evidence, that the failure to understand instructions is not evidence. That was all adduced to trial, adduced under this record.
Under Draft House 50's position, that is at best subsequent intoxicated condition inference. It's not subsequent intoxication. It doesn't meet that standard because this case is different than Smith. You have no evidence that there was at the bar, at the time of service. Remember, we're talking about moments in Smith. And the court extends the inference in Smith only because, to survive summary judgment, together with the destruction of evidence. And so this is not a subsequent, you've got location discrepancy, temporal discrepancy, and the nature of the intoxication is totally different. What the evidence in the record is, and this is Officer Graham's testimony, anything that's on the video, he says, yeah, she doesn't stumble. She doesn't have any problem in those interactions with me. And again, the court is, to the extent that plaintiff would have the court conflate what her BAC is, absent interpretation after the fact with how she presented after her second beer is inappropriate. And it misunderstands the DRAM standard.
Thank you, counsel.
Thank you.
Mr. Norris, you may present your rebuttal.
First, I'd like to comment, and I think Judge Wiggins actually said most of what I was going to say in respect to this. It's not just the BAC. I think that's come out in the record here today, but it's not just the BAC. All the things that were mentioned earlier, the bloodshot watery eyes, the slurred speech, the fall instructions, the emotional state, the balance issues that she demonstrated, there's an inference, a very reasonable inference that can be drawn from that by the fact finder, and that is that those same observations that were available to somebody who had no idea that she had been drinking alcohol at a bar would have been available minutes earlier when she was at the bar.
Well, let's examine that, because the legal standard is not whether or not the patron was intoxicated, but whether the waitress or the bar knew or should have known that she was intoxicated. So can you take an inference that would permit a police officer to conclude that we could conclude that the officer knew or should have known that she was intoxicated, and use that inference to apply to another person?
I certainly believe you can. First of all, I would point out, well, let me point
How
out.
can you take an inference that's applicable to one person and apply it to another?
The code is not only that they were intoxicated, knew or should have known that they were intoxicated, or it also provides that they knew or should have known that they would become intoxicated as a result of the service. And the inference that can be drawn here is that this is somebody who is significantly impaired. And I would point back again to the language in the Ward case that was cited by this court in Shagnasty, that even the service of one beer to somebody who shortly thereafter is determined to be significantly intoxicated gives the inference that the bar that served that one beer at the very least should have known that they were or would become intoxicated from the service. And that's the inference that I think.
Well, do you have to describe some circumstances that would allow that inference that one person can make to be applied for another person to also infer?
Time. Time is probably the most important fact in that. What I mean by that is these observations were made only minutes after she left the bar. the reasonable inference that can be drawn is these observations were all available to anybody who would have observed her before she left
Well,
the bar.
it's an inference from someone who's trained to, and is an expert. Are we expecting that of waitresses?
Well, the waitresses are in a better position to evaluate the level of intoxication of a patron by virtue of the very fact that they're the only ones giving the alcohol to them. And that's the entire intent of this dram shop statute. If you're going to be given the right by the state of Iowa to serve alcohol, you better make sure that you don't do it to the point of intoxication.
I guess I want
No,
to,
that's a strict liability standard, right?
Yeah, and
That's
that's-
not right, is it?
Well, and that's
Perhaps
my
I was
point,
short
is
with
that
that.
should we be looking at the evidence that would allow us to infer that that waitress knew or should have known?
The inference that whoever served the alcohol knew or should have known. And it's possible, as in at any bar, that there may be more than one employee at one time or another who is serving an individual patron alcohol.
I'll tell you, there's just a couple of things I want to say about this. Number one, and Justice Mansfield just mentioned it, it's my problem is that it appears to me that we're going back to a focus of strict liability on the part of the dram shop individuals here. And secondly, I really struggle with the idea that this is in fact a reasonable inference that you can make an hour or so after the last service of this individual, because you're only entitled to have an inference of this if it's not subject to speculation and conjecture. And I see speculation and conjecture all over the place when the record, as I understand it, is that the last service of this individual was at 7:30, well over an hour before that. And now you're saying that the observations of the officer an hour or more after the last service is supposed to now relate back, and the waitress or the bar should have at that point been able to make all these observations, and that they then, under those circumstances, an hour before, should have made this determination that they knew or should have known the person was going to become intoxicated, and that they knew or should have known that they were in fact intoxicated at the time. And I just don't see this really being an appropriate inference of that information. So
I would respond to that, permission for more time, thank you. I would respond to that first by pointing out what's been pointed out earlier in respect to evidence that the fact finder can accept or reject. The evidence that her last beer was served at 7:30, again, that came from the individual who was under investigation for OWI and then subsequently was a defendant in a punitive damage claim in a civil case. That can be rejected. So the inference actually goes to the time that she left the bar. She left the bar only minutes before.
well, just how can you just say that we can just reject that, because it only came from her? Well, what's the evidence other than that? What evidence in this record is other than the fact that she was served that last beer? The other persons bought the beer at 7:30, and that was it. There's no other evidence in this record, is there?
I would argue that the significant state of her intoxication is the evidence that she'd had beer later than 7:30. This is not somebody who is at the line of intoxication. This is somebody, by anybody's definition or standard, was significantly intoxicated, and that's the difference. You have somebody with a blood alcohol level of 0.143 who just caused an accident by hitting a car that was stopped at a red light, who is crying, laughing, all these things that we talked about. There's an inference that can be drawn from that she was significantly intoxicated minutes earlier when she left that bar, and that she's consumed alcohol at a time later than she states to the officer. Thank you.
Thank you very much, Counsel. The case is now then submitted, and we'll next hear the arguments in Larson.